All right, good morning, good morning, good morning. It is May 9th, and thrilled to be joined today by Ben Singer, which we'll introduce in a second. First, some caveats. Actually, interestingly, you guys all kind of know I start these things at 10:02, and I'm noticing how many people are now jumping in at 10:02. So my strategy of waiting that extra 2 minutes is now backfiring as people have kind of started to learn my ways. But anyways, as you were aware, I get the first 3 minutes and then we turn it over to the speaker. So very quickly, our forums are private. These things are public. Anything you say will be out on public forums, be advised. Second, there's just a host of really great forums to consider joining. If you have an interest in real estate, I know a lot of people who see these videos aren't even aware of our forums. And it was pointed out to me that perhaps I should be mentioning the fact that, there's a host of forums that are there to educate you and that have seasoned professionals who are seeking to better their understanding of real estate, that you should consider joining, particularly on Facebook. We run the Ontario Real Estate Legal Discussion Group. There is a subgroup for landlord-tenant issues. There's a subgroup for TRESA issues for the transition. In addition, there's Real Estate Strategies, the Real Estate Collective, and a host of other places where agents do regularly congregate and where the discussions take place. So I would encourage you, if you are not part of those groups, to join. You'll learn a lot. You generally have to be one of our professionals, but if you're a lawyer, if you're a realtor, if you're a mortgage broker, seeking access to some of the groups, certainly absolutely in order, and I would encourage you to do it. Let's get down to the order of the day. I am joined today by Ben. I'm thrilled to be joined today by Ben. So Ben is a member, a longstanding member of our group, and actually I have communicated with Ben on multiple occasions about certain problems I've had in the new build space. And the reason for that is because and you guys all know this because you're seeing these videos and you're experiencing it, all conveyance lawyers are not the same. And particularly, there is a division between those people who act for purchasers routinely in the new build and new construction space and those people who act for developers. And Ben has deep experience in acting for a commercial real estate practice, where he basically assists developers in the acquisition of land, in the development of products, and then sells to lawyers like me, who then beg him for adjustments and tell him that we need amendments and God knows what, and he writes back those curt letters that you guys are all receiving. But he is one of the good guys, I assure you. Not only that, his knowledge is replete. I know he has been a practicing lawyer in this space for, I believe, close to 10 years. After about 5 years, I find that professionals who exceed in this space really kind of start taking off. So Ben is well within that rubric of young and active and yet knowledgeable. And to that end, he's here to talk to us about the new development process in a way that only someone of his vintage can, and in a way that only someone of his experience can. So Ben, thank you for joining us. Thrilled to have you here. It's 10:06. I took up one of your minutes, so floor is yours. You're good till 11 o'clock. Thank you very much.
Thank you, Mark. And I do need to correct two things. The first is Mark has never begged me for anything. He's browbeaten, he's cajoled, but he's never begged. The other correction is now that the camera is a little more focused on me, you can see I've got the gray. I'm not so young anymore, but I'm working on that. I'm trying to be youthful. You can see my baby in the background. She keeps me a little bit young. So I'm going to share my screen and start our presentation for the day. So I'm going to be talking about new construction agreements, and I wanted to bring this topic to the group because we do a lot of work. Obviously, our firm does work with larger developers. We do work with smaller developers, and a lot of the time single-family homes that are being developed on an individual basis. And we do on those, as well as sort of subdivisions where closings have mostly happened and there's stock being sold on it's new stock being sold on the resale market. And in those two categories, a lot of the times we do get in agreements that have been drafted by realtors or by other lawyers that aren't necessarily in the seller's best interests. for a couple of reasons. So I wanted to bring, I guess, some information and considerations. So the do's and don'ts, which are really regulatory matters that must or must not be done or complied with or what have you, and then considerations, things to think about that might be beneficial to your client, to the purchaser, but potentially beneficial to everybody. So who am I? Like Mark said, I'm a development lawyer. I also do some private lending and commercial leasing work, but really the focus of my practice is on subdivision and condo development, taking projects from start to finish. So we help with acquisitions, construction financing, and developing, if it's a condominium, the disclosure package, through the registration process, and obviously out to sales. So sort of everything essentially except for construction lien law, I really don't touch. It's a very specialized area. And municipal planning, to the extent that it becomes a dispute with the municipality, we're not litigators, so we defer that over. We have a few referral sources. But at a high level, everything start to finish, whether you are developing a single family home or a 500-unit condo, that's sort of where we sit in. So the first question to ask is, what is a new home? What is going to be captured by these kinds of agreements and by this sort of regulation? And the important point to highlight here is who decides what is a new home for what purpose, because there are all sorts of parties trying to insert themselves into this sort of transaction. And we need to isolate out who the decision makers are to isolate out what matters, because our first decision maker is going to be the city. When your client is going out to build this new home, they're going to need to get permits and pay fees. And the difference between a new home and a renovated property is going to be significant for those fees and for those permits, for what they need to comply with, the sorts of drawings you need to bring in. The important point I want to hammer home here is this decision by the city has absolutely nothing to do with the rest of this presentation. It is only determinative of the fees and permits that are going to be paid, and other regulators don't abide by the same definitions. So if, for example, a vendor comes to you and says, I want to sell this home, it was renovated. So, and by this permit, it was renovated. So, you know, HST and Tarion don't apply. We'll get into those in a sec. But the city's definition of a renovated property has absolutely nothing to do with what our other regulators are going to decide. So our first regulator that we need to consider is Tarion, the New Homes Warranty Corporation. And they are crucial because under their definition of new home, you have an obligation to provide a warranty for that home, and you have an obligation to insert certain documents into your purchase agreement. You also need to consider the CRA's definition. This is crucial for HST. So because HST is such a significant component of new homes, I'm going to deal with the CRA first. So I'm throwing this number up, 13%, less input tax credits, because that's the risk to your client of getting the decision wrong of whether there is HST or not on a deal. That is a lot. In our experience, we're usually looking at projects with a 15% profit margin. So this can obliterate essentially all of your client's profit. Or if you want to look at it from another way, your commissions will be around 5% total, 2.5% to listing, 2.5% to the cooperating agent. This is more than twice that. It is something you can't afford to get wrong. So what we have to understand first and foremost is that it's not that HST specifically applies to a new home. It is that HST applies to everything, and there's a specific exemption for used residential. So off the bat, if you know your client is building a new home, you know that HST applies. You don't need a special legal opinion. You don't need an accountant to review the file, because if you know it is a new home, so new foundation, new walls, new everything, if you're advertising as brand spanking new, you know HST applies. There is no exemption for new homes. You must ensure that you're pricing with HST in mind. And the other important point, and this is where the city definition of renovated property really comes in to confuse matters. HST also applies to a substantially renovated residential property. What does substantially renovated mean? I've exerted the definition from the Excise Tax Act. And I think what's important here is the CRA also provides guidance. And as part of that guidance, as a rule of thumb, they tell you if 90% of the floor area is renovated, HST applies. They also tell you in that same guidance, don't rely on this number because other factors may apply. So when you're dealing with a substantially renovated property, the first thing to note is HST may apply. So the way I think to look at the problem is if you know your client has done substantial renovation. So we're not talking about sort of taking out just a kitchen. We're not talking about laying down just new flooring on one floor. We're talking about something substantial. The question really needs to go to either the client's lawyer or accountant as to whether to consider this a substantial renovation. Just measuring the floor area that the renovation affects isn't enough. It really is a much more complex situation, and you need to review to ensure that you are pricing correctly. So when it comes to new builds, there are sort of two ways to think about pricing. And the ORIA agreement really factors this in when it was drafted. You can have HST included or HST excluded from the purchase price, and then put the HST, call it risk, on one of the parties or the other. So with new builds, we generally see pricing with HST included and also the HST rebate factored in. I'm going to talk about the HST rebate in a sec, but essentially, if you are selling a property where the developer needs to see $1 million of revenue, you would price it at $1 million plus 130,000, which is roughly the HST, and then minus the HST rebate, so 1,106,000. I think I got the math right there. I'm just doing it in my head. So you can either present that as the purchase price, note that HST is included and the HST rebate has been netted out from the agreement, or you can simply price at $1 million and include that in the agreement that HST is not included in the purchase price, and believe the standard form of ORIA agreement says, if HST applies, then it will be added on closing. And again, whether it's a new build, definitely, or a substantial renovation under the definition of the Excise Tax Act, HST definitely applies. So this is one of those items where you do need to ensure that people understand each other and understand what is and isn't included in the purchase price. And it has to be in writing, because on $1 million house, which on new build, that would be a very cheap house. Let's be honest with our current market. $130,000 is a lot of money. And it's a lot of money if it's the first time the purchaser realizes that there's something going on with HST, is 5 days before closing when they receive a statement of adjustment, and lo and behold, HST is there. So you create a lot of closing risk where people are scrambling for $130,000 they didn't have before. You want to make sure, even if you're acting for the vendor and you've written the agreement right, you want to make sure that the cooperating agent understands that this is an HST deal, especially if you are pricing HST exclusive. So the HST rebate. Does the purchaser qualify? So I guess the first note is the HST rebate is a refund of HST that comes from the government, specifically to the purchaser of a new home. Now, there are two forms of rebate. We generally only see the rebate assigned when it is the new home buyer's rebate, which are the qualifications that you can see on the screen. There is also a rebate for investors. So keeping in mind that what you don't really want to do is try to trick people into having one rebate when really they would already qualify for the other, because they can end up disqualifying themselves for both. So we generally see the HST rebate priced into the purchase price because it creates a cash flow benefit to the purchaser. So assume it's not being priced in, $1 million house, $130,000 of HST. all that money gets paid up front, and the purchaser would then go to CRA, send in an application, and a couple months later, they would get back $24,000. It is beneficial to the purchasers to not have to wait that time to get that money back and to see it upfront on the agreement. And then the developer who has HST input tax credits and HST remissions to write off against gets to take the benefit of the HST rebate and use that money essentially sort of as soon as their taxes are filed. So the important point here is if you are pricing it in, to make sure in the agreement, the purchaser is representing that they do in fact qualify for the HST rebate. There are three essential terms of qualification. The first is what's the purchaser's intention at the time of the purchase. So if they intend at the time of the purchase to use it as investment property and things change and they happen to use it as a personal residence, they technically do not qualify for this rebate. Now, how would CRA know? I don't know, but they wouldn't qualify. The second thing is the purchaser on the agreement must be the person who takes title to the property. And this is an important point because a lot of the time where we see disqualification, it's a little bit silly. The purchaser is one person. They may have gotten someone else to come on title with them to qualify for the mortgage. And instead of assigning the agreement from the original purchaser to both parties, they will use directionary title. So they take title together, which is generally a fine thing to do. But because the particular individual did not take title, the particular individual on the agreement did not take title to the property, they are disqualified. So the important point here is more for end closing procedure is to make sure either the parties who are intended to take title are original parties to the agreement or an assignment agreement rather than a directionary title is used at that point. I think that's more a point for the lawyers in the group than the realtors, but it's something to note in the background. The third point of qualification is that the property must be used by the purchaser or direct family members as a principal residence. This has to happen for, I believe the qualification period is approximately 1 year. There's contextual questions that come into if somebody moved out after 11 months, what their intentions were, but fundamentally, they must use it as a principal residence. So there's 2 points of qualification here. One is that someone coming on for 1% who is not a family member, say a friend who's being used to qualify for a mortgage, that can kill your qualification. And the other item here to keep in mind is that if the purchaser does not actually qualify, so they close and they put in a tenant or they immediately list the property on the resale market, the developer may want to claw the HST rebate back. The reason being, if CRA determines that the purchaser did not in fact qualify, even though the purchaser at the time of the sale seemed like they did, the seller may be held accountable for that $24,000 of HST. So drafting notes, again, include as a representation or a covenant on closing that these 3 items will be true, and include as required documents on closing that the purchaser must deliver an application to CRA for the HST rebate, an assignment agreement of that HST rebate. So this is an assignment between the purchaser and the vendor, and a requirement that they sign a statutory declaration on closing that that all of the qualifications were at the time of the agreement being signed and are at the time of closing still true. So between these 3 documents, your vendor shouldn't have problems getting the HST rebate. So that's HST. That's one crucial element. And just to say, again, getting this wrong, your risk is a large amount of cash. The application of the Tarion warranty is, to me, a much more important area to get right. Why? If you get HST wrong, it's money. Your developer client may lose money on the transaction, but it's just money. Under the New Homes Warranty Act, a seller of a new home must be registered with the Home Construction Regulatory Authority as a vendor. And if they are the ones who built the home, they must also be registered as a builder. Otherwise, they must use a registered builder. And they must be qualified for enrollment with Tarion before a home ideally is constructed, but certainly before an agreement with an end purchaser is reached. If they don't comply with the New Homes Warranty Act, any agreement that is reached with respect to the sale of that property is potentially voidable. Why is this? If we think sort of backing up into fundamental law, you can't contract to do an illegal thing. If Mark decides to pay, I not cooperating with one of Mark's demands for a purchaser, and Mark decides I got to take out this Ben Singer guy. Mark pays someone on the internet to come kill me. Mark pays that money, and that person does not kill me. Mark cannot go to court and say, I have a contract, you must enforce it. I paid him money, he didn't kill the guy, at least I should get my money back, right? No, the courts will not enforce that contract. An illegal contract will not be enforced. Now that's for potentially criminal matters. When it comes to acts that are seen in the light of consumer protection, it's a little bit different in that the courts will still not enforce an illegal agreement that does not comply with the act. But if you can make things legal, then the court may still enforce it. So, for example, if you sold a home before you were registered with Tarion, but then became registered with Tarion, the courts may enforce that agreement, provided that the benefits of that new of that consumer protection legislation were actually afforded to the purchaser. So, if your vendor is not registered with Tarion, is not registered with HCRA, they have no way to come into compliance with the act, and that agreement is potentially voidable up to the time of closing, which is a huge problem in a falling market. Your purchaser may otherwise be totally happy with the property. They come back the day before closing, their mortgage won't fund. They say, sorry, I'm out. You say, we have a contract, I'm going to sue you. They say, you didn't comply, I'm out. You try to sue them, the purchase, not only will the vendor be losing the deposit back to the purchaser, but you get put on Tarion's radar. And Tarion right now is on an enforcement kick. Too many developers have skirted the law for too long, and Tarion has been treating that with a vengeance, if you will. Developers are being named and shamed, they're being fined, and they're having their license to build where they've otherwise complied, they're having that revoked. So your client, in entering into one of these illegal agreements, may not only be harming themselves in that one agreement, but they may be harming their future prospects in all of Ontario. So, under the New Homes Warranty Act, there's no opt-in, there's no opt-out. A new home must be enrolled. Now, this is where definitions get important and a little bit interesting, because a new home under the New Homes Warranty Act is very different than how CRA treats new homes, because CRA includes renovated properties in the applicability of HST. Tarion does not. So if you have a substantially renovated property where HST might apply, the Tarion warranty may still not apply. Where it's a question mark, this is again something I would strongly recommend bring to a lawyer. So your client has maybe knocked down 3 walls of a property, have gotten a renovation permit rather than a new construction permit from the city. That's where you bring the question through a lawyer or directly, but I would recommend going through a lawyer to Tarion to ask, essentially, are you going to make me enroll this home? Is the work that I'm doing new enough that it qualifies as a new home? Or is this essentially, in Tarion's eyes, a renovation? The reason for that difference is important. Tarion wants to ensure new homes are constructed properly, are waterproofed properly, are otherwise built in a good fashion in compliance with the building code, and they are going to force the developer to stand behind it. But if the developer goes up Tarion is standing behind it. So if you have a development that is partially already constructed, and Tarion has no way to know how well the foundation was done because the foundation isn't being touched as part of the new build, Tarion doesn't want to qualify that as a new home, and they don't necessarily want the warranty to apply. So it's not a matter of opt-in or opt-out. There is no choice. Tarion offers 1, 2, and 7-year warranties. If you are dealing in new homes, you're going to want to familiarize yourself with what exactly is being covered there so that you can communicate that properly to potential purchasers, and also so that your client understands what they are standing behind. So as a recap, there's no choice. You must register with the HCRA as a vendor and or as a builder, and you must, prior to sale, go to Tarion and obtain qualification for enrollment. Now, if you are doing renovation work, if your builder is doing renovation work, they may consider providing a warranty and standing behind their own work. This is where you want to be extremely precise in what the warranty terms are. So a lot of the times, builders will simply say, I'll cover whatever Tarion will cover, and they won't necessarily know what that means. So there are things you want to consider, like how long the warranty is going to last, what your potential caps on that warranty are going to be, and I think this is the most important and crucial thing, what happens in an emergency situation? So a leak has sprung up, the bathroom is flooding, what do you do? Is that warranted or not is the first question, but the second is, who do you contact? Because what you don't want your client stuck with as a builder is something happens that would otherwise be warranted, that they're obligated to pay for. You don't necessarily want the purchaser calling an emergency plumber who does emergency patchwork that really does more damage than good over the long term. And then the warranty rectification is longer. You want probably your builder to be the first point of contact. So ensuring that a private warranty is properly drafted is a crucial component. And that can either form part of the agreement, or the agreement can provide that the builder will provide a warranty on, you want to, I think, explain the basic terms like cap and length, but that the standard terms will apply, and then on closing, provide those standard terms. So those were the two most crucial things for advising new home builders or new home renovators on how they are going to go about essentially complying with the law. The rest of this presentation is more about things that I think are good ideas to include in purchase agreements and that are highly negotiable. So the first is adjustments. And I think a lot of people see adjustments as a money grab for the developer, that they're pricing at $1 million, but they're hiding in hidden fees that are really meant to gross up their profits. And I think the perspective that I take is that proper adjustments, because that can be the case, hidden fees, but proper adjustments are a matter of risk allocation. They are saying, I don't know what, for example, development charges are going to be. I can enter into this agreement before the development charges are fixed. So I'm not pricing those in to your purchase price. I'm leaving them out of my consideration of what it's going to cost me and what my profit is going to be. And on a one-to-one basis, you're going to pay me back for development charges, or I'll price in the current development charges, and any increase in the development charges, you purchaser are going to pay me back. So potential areas of risk allocation, things like development charges, construction cost increases are a big one. Both we saw in the last 4-ish years, a massive increase in construction costs as COVID sort of threw the supply chain through a loop. We also see a lot of potential requirements in the municipality, so above and beyond development charges, on what you're going to be required to do to the property. Things like landscaping and planting, what your grading is going to look like. Some developers also exclude paving costs. I'm a little more on the call it money grab side on that one. And you're entitled to whatever adjustments that you put in as long as you disclose them. But if you're building a new single family home and the picture has a driveway, separating out the paving costs, I think unless they're really variable, is a little bit silly. And sort of any development fees or taxes, things like that, might be also adjustments to consider. Now, the important point is you can include these in the agreement, but for a new home construction where the Tarion warranty applies, they must also be listed on Schedule B to the addendum. Wait a minute, what's the addendum? The addendum. So I've excerpted the first page of the addendum. It's a roughly 12-page document. So the most important part of the addendum is that it sets out the critical dates for closing and occupancy of the home. There are multiple forms of addendum. So the one that I have here is called the tentative closing date addendum. You can see what form it is right up here. So in this sort of product type, you're likely dealing in freehold. So the freehold addendum with a tentative closing date, what it does is establishes the first tentative closing date. So where you think the developer is going to be able to provide occupancy of the home, that's your first tentative closing date. The tentative addendum allows for specific adjustments to that closing date. So by 90 days notice, you can extend up to 120 days, and you can do that twice without paying any sort of compensation to the purchaser. So essentially, you get almost a year of potential extension. This is to account for the fact that developers may have issues delaying that aren't really part of their fault, but are relatively predictable. So as long as they give that 90 days notice, they get these free extensions, and then the termination of the agreement by the purchaser, if the developer is even further delayed, can only happen by this purchaser's termination period down here. So ordinarily, as you know, closing date comes and goes. Time is of the essence. Time is still of the essence for the purchaser, which is, I guess, a one-sided element of the addendum. But for the seller, as long as they comply with the terms here, they can push off closing dates. So, as discussed, you can't sell a home without the addendum, a new home without the addendum attached. It is a part of the consumer protection legislation of the New Homes Warranty Act, and an agreement without the addendum attached is, again, potentially voidable by the purchaser up to any point, including on the closing date. If you have the addendum attached, you do sort of not have to worry about that potential risk. So what the addendum deals with is first the closing dates, and this can either be tentative or fixed. So on a fixed addendum, you don't have these extra tentative closing dates. You only have one fixed date. The developer can still extend, but they will always, on a fixed addendum, always have to pay delayed closing compensation. So what you want to do is restrict use of the fixed addendum to either projects where the house is already constructed, or where the construction schedule is so firm that you know with great certainty that you'll be able to hit that date. The addendum also contains rules for notices, so it will have the proper contact information for delivering notices. I know that the ORIA standard form agreement also has contact information. The addendum overrules that, so you must ensure that if there are going to be, say, a tentative form addendum, you must ensure that there is contact information, especially email addresses for notices, because that's the email address that if you serve a notice at, you're free and clear, your extension is effective. If that email address is not there, it's a question about whether it was properly served. So the rules for how to set outside closing dates, the rules for delayed closing compensation, the rules on unavoidable delay. This is a topic that comes up a lot, came up a lot in COVID, but comes up a lot when there are supplier strikes, weather events, things that would push off the developer schedule that aren't part of the normal development process. And it has rules for the conditions of closing, namely, you must on new builds have an occupancy certificate from the municipality, or if the municipality doesn't issue occupancy certificates, you must at least be able to prove that all building permits have been closed before the purchaser can be forced to take title. So another element of the addendum I'm not going to go into too much is early termination conditions. These are things that allow the vendor, to terminate the agreement early. Essentially, they're there to set up for projects where the vendor is questioning whether they will actually be able to develop the project. This is something where you do certainly want to consult with a lawyer before drafting, because the early termination conditions are very specific. They can only be used in very specific circumstances. And there's a lot of interesting case law that goes into where they can be used and how they can be used. You're also going to include in the addendum disclosure of planning and construction status. So you need to disclose to purchasers things like, do I have zoning for the site? Do I have have I commenced construction yet? Or when is construction expected to commence? Things like that. Do I have water allocated for the site? Those are crucial components that must be included in the addendum. And finally, Schedule B of the addendum will list out every single one of your adjustments. So even adjustments that you don't necessarily think about, like the standard realty tax adjustments. If the realty tax adjustment is not mentioned in Schedule B, it is technically not chargeable, and the seller has to eat the realty tax that they've already prepaid. Super annoying, technical matter of law. The thing to remember is that the New Homes Warranty Plan Act is consumer protection legislation. It is meant to benefit consumers, and if you are a seller that is technically out of compliance, it will be held against you. The other mandatory component is the warranty sheet. So there are different warranty sheets for different kinds of new homes. This is the first page of the new freehold homes. So generally, if you're a developer building a new single family home, whether it's a single family home or on a plan of subdivision, this is what you would provide. It must be attached to the agreement. Again, consumer protection legislation, if you're not in compliance, the deal is potentially terminable. Now, this one is a little bit easier to comply with in that as long as you give over the information, the deal is potentially salvageable. Okay. Don't take that as an invitation to deliver it on closing rather than deliver it as part of the purchase agreement. But if it hasn't been delivered as part of the purchase agreement, it's something where you want to deliver it as soon as possible, apologize for the mistake, and have the purchaser acknowledge that they've received it so that it potentially won't be held against the vendor at a later date. Now, other drafting considerations. So first, homes built on spec, meaning there's no shovels in the ground at the time that the purchase agreement is signed. You want to consider things like selections and potential delays caused by selections. So a lot of the times purchasers either want to do sort of upgrade packages or want to customize their home. So there need to be provisions on how that process will work. Whether it is coming into a builder selection office, or there's an online meeting, or there's emails that will be exchanged back and forth, how that process will work. And if delays are caused, at whose risk will they be? Because selections are a normal part of the process. The addendum that you have attached doesn't include that as one of the unavoidable delays. It is a very much avoidable delay. So if there are delays in selections, you want to either include provisions like the builder will just make selections for you and move forward, or that potentially, if the agreement is not complied with, that the selections are not selected within the period of time, that the agreement is terminated, that's the default. Now, it's an aggressive default to enforce, but having a stick to bring people back to the table is sometimes necessary. Other elements of the spec homes agreement that you want to consider are representations and warranties about what the finishes will be, what they will look like, and what they won't look like. So this is especially true when you're dealing with natural materials like wood. You want to ensure in the agreement that any representations about those finishes are caveated by things like natural considerations, that there are natural variations in wood grain and wood patterns and imperfections, imperfections in stone, imperfections in all sorts of materials that the builder is not warrantying will be perfect because they're natural materials. Colors can warp in sunlight, all those sorts of things. You also want the ability for the vendor to be able to substitute things. So the vendor may promise X brand of appliances as part of the package, and X brand God forbid, goes out of business. Or maybe the price shoots up at the time that they were going to go purchase. So you want the ability to substitute with something of equal or better quality, because you don't want to be in a position where your vendor has technically defaulted on the agreement. Now, a little bit of color warping, an imperfection, what are the purchaser's real damages? But the purchaser, may be disappointed with what they get, and they may drag you into court. The third item you want to ensure is in there is that there are no collateral representations. What's a collateral representation? So in the agreement, I'm going to promise a certain level of finishing. I'm going to promise maybe the spec design, but in the sales office, there will be drawings and there will be marketing material. And all of that is it's specifically meant, and you can't really make the argument that it's not meant to induce people to buy. So the agreement must specifically exclude collateral representations from the agreement itself, because a representation, which is found to be material to the purchaser's decision to buy, may bind the seller. So it has to be excluded, and that clause needs to be pointed out as part of the selling process. That purchaser, listen, all you are getting is what's in this agreement. I know I showed you these beautiful drawings, beautiful landscapes, beautiful that, none of that counts. Just what's in the agreement is what counts. And that's where, for the vendor's benefit of dealing with a purchaser who understands what they're getting, you may also want to put in a conditional period in favor of the purchaser, just so they can take the agreement, take it home, review it, because these are usually big agreements, review it with a lawyer and come back and say yes or no, I actually want this or I actually don't. So specific to new construction, whether it's a spec home or already built home, there must be a pre-delivery inspection. This is something Tarion requires. And this is not a requirement of Tarion, but it is a very good idea, a right of re-entry into the home. So the ability of the vendor to, as of right, come in and fix things, because the purchaser may make complaints about the quality of this or the chipping of that, or on their pre-delivery inspection, they noted 30 or 40 defects. They also may not want the developer in their home. So that can get tense. And what you want to be able to do is assert the right to be able to come back in, because you may need to. Or there may be grading requirements from the municipality that aren't being complied with, that the purchaser has done on their own. They've redone the grading, they've installed a pool where it's illegal. The developer is being held accountable by the municipality for this. You want the ability to walk on as of right and do your work. For all homes, you want to consider, because sometimes the new build process is a little bit longer, you want to consider how deposits are being held, and specifically whether they're held in an interest-bearing account. Interest rates right now are significant. So, holding a deposit for 12 or 16 or 18 months is a significant factor. So you need to agree specifically where it's going to be held and who gets the benefit of that interest. Does it count towards the purchase price, or does it get credited to the developer? The other consideration for deposits is the developer may want to, on new construction, have access to those deposits. So that's something that needs to be negotiated in or out as a standard matter of practice, especially if you're using the ORI agreement as your base. Deposits are to be held in trust. So that has to be negotiated out. If you're using a developer standard form, it's usually not held in trust, usually released to the developer. So if you want, as a purchaser, deposit protection, you need to negotiate that in. And that deposit protection can either be deposits held in trust or requiring the developer to get deposit insurance. So an insurable product the developer will pay for that then lets them use the deposit. And if they go under, the purchaser has recourse. A point to note is that on freehold homes, there is a deposit maximum of 30%. Where does its deposit maximum come from? It comes from the Construction Act, because if you go over 30%, a purchaser of a new home can end up liable for construction liens that they otherwise might not be. So you really want to never put people in that position, and you really want to cap deposits at 30%. This doesn't apply to condo, by the way, but we're also not talking about condo today. So consider that for freehold, the rule. You want to think about additional deliveries and documents on closings. So if there are utility accounts that need to be set up at first, you want to ensure that you have proof of that. If there are HVAC or smart home leases, so if you're developing a smart home, you're developing a product with HVAC or sometimes other appliance systems have leases, you want to require in the agreement that these things be entered into. And if your developer's doing work in the neighborhood, they're doing work on adjacent properties, or this is in a new subdivision where there's still work to be done, you do want to ensure there's a non-objection clause in there. What you don't want is your new home buyer to come into the house and immediately turn NIMBY and show up at development meetings protesting the developer's work. It's very counterproductive. It's a little bit hypocritical, but it's very counterproductive. And you do want a part of the agreement that you can point to that says you are prohibited from doing this, you are legally stayed. Its enforceability isn't necessarily clear because once the agreement is closed and the agreement's merged, your ability to actually enforce parts of the agreement may go away, but at the very least, you can point to something. As a final point, you do want to include points about site safety in the agreement. Specifically, I would definitely recommend for projects under construction, whether you are just starting out or there's still finishing touches to be put on the home when it's sold, no right of access. The purchasers generally in resale homes do have a right of access. Usually you'll see they get 1 visit, they get 3 visits, they get unlimited visits. A new home build is a very different beast, and there are potential dangers that aren't necessarily predictable. So no right of access as of right. If you're granting access, it needs to be supervised and controlled. So you don't want purchasers going anywhere in the home without, say, the site super or someone else who knows the site very well, who can keep them safe. And you want to be able to require them to wear safety equipment. That'll be a condition of access to the site. Throwing it in the agreement just gives you that extra reassurance that you can force it on people. You also want to require that if they are coming into the site, things happen. You want an indemnity from the purchaser for any damage to them or any damage that they cause to the site when they are there, because things do happen. And frankly, a site visit from the purchaser on a new build, in my opinion at least, is not worth the potential damage that it causes without having the assurance that the purchaser is essentially going to cover the developer for it. Now note, the pre-delivery inspection, you can't necessarily caveat with this stuff. You can require, say, hard hats and safety equipment going through, say, a condo under construction, or there's still work to be done on the home a little bit, but you can't, say, make the purchaser indemnify you for the pre-delivery inspection. That's sort of above and beyond pre-delivery inspections that right per the New Homes Warranty Act and the Tarion requirements. So we didn't cover condos today. If you are interested in condos, I did want to plug my appearance just for a second at the Missing Middle Summit coming up on 2 weeks today. So I think that's May 23rd. If you're interested, come check it out. I'll be speaking about condos. Other developers will be speaking, or developers, planners will be speaking about sort of this space of a multi-residential. And my contact information is up there if anybody's interested. And it's 10:51, and I've got time for questions, I guess.
Awesome. Thank you so much, Ben. This has been this is actually more than I expected. I'm just going to, before we turn to questions, I'm just going to point out one quick thing, which is there is a reason people are experts in the area. Not all lawyers are the same. You can tell from Ben's talk what the benefit of experience in an area is, which is vastly different than those people who are approaching this at the get-go, using professionals in the space. I know I'm speaking to people who already subscribe to this ethos, but using professionals in a space pays off in spades. So let's open it up to questions. Guys, feel free, unmute yourself, ask your questions. Let's go. Who wants to be the first brave one? Hold tight, Ben. Takes people usually a
Hey, my name is Vishal. Can you hear me, guys?
Yes, go ahead, Vishal.
Thank you, Mark. Ben, thank you so much for this session. This was really very informative and very insightful. Um, the question that I had was when it comes to a single home development. So a property where there was a house already and the person is demolishing it and building up the whole new thing and selling it. When it comes to that situation, all the things that you mentioned here, as in like having an addendum or the considerations that needs to be taken care of, has to be still there, or is it only applicable to the developers generally?
Yeah, all of this applies. If you are selling what is a new home, it applies. So in that example, I can tell you with relative certainty, if your developer's carrying out the foundation, 100% that's a new home. There are no pre-existing elements. If your developer is replacing a kitchen, or your seller, we're not calling them a developer, your renovator is replacing a kitchen, not a new home, Tarion doesn't apply, warranty doesn't apply, addendum doesn't apply. In the middle is where it becomes an interesting question. So if you're keeping part of the foundation or you're keeping the foundation in one wall, that becomes a question as to whether Tarion considers it the act to apply. And that's where I am of the opinion that rather than go to Tarion directly, you do want to go through a development lawyer first to give you an opinion on what their opinion is of the facts and whether it's a wise idea to go to Tarion to determine or to keep it off Tarion's radar. I will tell you, I will generally err on the side of caution, but I have full respect for my colleagues who are willing to look at the act and make a sort of more liberal interpretation. But you want that opinion, and you want that opinion to protect your client from the potential consequences, because lawyers are insured. If they are giving you a legal opinion and they turn out to be wrong, you can and should sue them. I say that about myself as well, but please don't sue me. But you probably should. If I give you advice that is bad and wrong, you should sue me. So you do, I think, want that that buffer between the developer and Tarion. But essentially, the question to Tarion is, I have half a foundation left. Does the warranty apply? Does the whole system apply? Do I work through you? And if the answer is yes, the answer is yes. If the answer is no, then you have that protection that you don't need to include the addendum, and the purchaser can't turn around and back out of the deal because, it's a new home, Tarion applies. Like, no, I have the answer from Tarion. Tarion doesn't apply.
And if I'm representing the purchaser, would he still be qualified for HST rebate in this case if he's using it for his property as a primary residence?
So sorry, I missed the first word of that. Remember that the Tarion definitions don't matter for CRA.
Yeah,
so CRA applies HST to substantially renovated homes and new homes. And so if the home qualifies for the rebate, the purchaser should qualify for the rebate.
Okay, sounds good. Thank you so much.
Yeah, if it's an edge case, again, go to an accountant, go to a lawyer. Generally, you can assume if it's a brand new home, HST applies, the rebate qualifies. If it's anything less than that, it doesn't hurt to ask. Like anybody sort of on a commercial basis building really should have a team of professionals on standby to work on these, to answer these kind of questions. And I want to say, the realtors are a crucial part of that, because I as a lawyer, I want to draft my agreement so strictly. And sometimes I need the realtors to pull me back and say, the market doesn't support this, Ben. Calm down.
All right, 2 more questions, guys, and then our time will be up. Who wants to be the brave questioners? Shanika, hit it up.
Hi, Ben. Thanks so much for a great presentation. So you mentioned that, if a builder is not registered under the Warranty Plans Act or with the HCRA, that any agreement with the buyer is potentially voidable. As a buyer, how do you go about figuring out whether or not the builder is registered under both of those entities?
So HCRA is very easy. HCRA maintains a builder directory. So all you got to do is go to the HCRA website, click on the vendor directory, and you want to look up the builder's name, maybe aliases, and if it doesn't come up, they're not registered. If it comes up and their license has been suspended, they're not registered. Tarion is a little bit trickier because Tarion doesn't publish qualification for enrollment information. And this is something that, even as a developer's lawyer, I really think they should. Like, it should be on the developer's sort of builder directory page. So if they have given you the addendum and they're on closing telling you that the warranty applies, they probably got qualification for enrollment. And frankly, if they're using the addendum, they probably got qualification for enrollment because the risk of saying, hey, there's a warranty, but also like don't ask Tarion about it, is pretty high for the developer. But there is also now the opportunity for purchasers to submit and pre-register agreements with Tarion. So if you go through that process, so you get your agreement signed, you send it to Tarion. If somebody hasn't gotten qualification for enrollment, Tarion's going to come back to the purchaser, most likely. I haven't seen it happen in the wild yet, but I assume that Tarion will come back to the purchaser and say, thank you for letting us know this is an illegal build, and we will be contacting your seller. So there's no direct way to check in advance for Tarion, but once you've signed, submit. I think it's totally legitimate. I think every purchaser really should submit, and maybe Tarion should even be requiring that vendors submit as a matter of right, so that Tarion can sort of match those things up.
Perfect. Thanks, Ben.
Okay, last question. Who's going to do it? One final question. Someone unmute and take the hit.
I'm going to take it, as I was so boring that half the people who are not on video have actually just fallen asleep, which I empathize with. It happens to my wife too.
Hardly, Ben. I think what's happened is you've approached a complex subject, and it takes people some time to process their questions. But I think Sandra is going to generate. I think Sandra, you're going to do it.
Actually, I'll tell you honestly, what your problem is you gave us too much information and it was too accurate. There are no questions.
Perfect. All right. So listen, Ben, I'm going to thank you sincerely. Guys, this was a session steeped in experience. I think you can all see that. When you have development questions, you need to go not to people like me. You need to go to development lawyers. They have specific expertise. They know this stuff. They live this stuff. They breathe this stuff. And you can see that in Ben's presentation. Ben, we're going to have you back for condos 100%. I think there will be overwhelming interest. I'll be posting this video. On behalf of all of us, sincerely thank you for your time, for your expertise, and above all else, for your generosity in coming and instructing us in an area that so many of us actually don't know very little about. I learned a lot. I'm sure everyone else did too. Thank you sincerely. And let's book you in for that condo session shortly. All right.
We'll talk offline. Thank you, Mark. And yeah, my contact information is still up, I guess, until the end of the meeting. So if you do have questions, take it down. I will be frank, like I'll let you know if I can just answer it or if I need to be retained or what have you. But feel free to reach out. I love this stuff. If that wasn't obvious, I really do. So
it is obvious, and it's very clear. You have a great skill set in it. So thank you on behalf of all of us, guys. This will be posted in the coming hours. Thank you everyone for attending. Let's wrap this up, and we are going to have a new session coming out in 2 weeks' time, which I'll announce shortly. Take care.
Ben, this was excellent. Thank you so much. Very informative.
Thanks, everyone.